mute button. Okay, and you'll be able to be heard. Okay.
Okay.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to call the civil dockets. As for announcements, attorneys, anyone who's present who doesn't have an attorney or your attorney does not answer, make sure I know that you're here, please. Otherwise, please keep your electronic devices muted. Getting in Karnes County, Martin Saldivar versus R Construction Company et al.
Your Honor, Jesus Garcia Jr. for the plaintiff here, Martin Saldivar.
Okay, and on the defense?
Good morning, Judge. This is Greg Laughlin.
Give me just a moment, I'm sorry. Give me just a moment. All right, I'm sorry. The YouTube feed popped up on me and started putting the sound in a loop about 5 seconds behind. Okay, I'm sorry. Who had answered?
Greg Laughlin for one of the defendants. We're not a player in this motion.
Okay, I see Mr. Butler coming in. He may be part of it. And Mr. Ortega, I don't see him.
Mr. Butler is also with the plaintiff, Your Honor.
Okay.
He's my co-counsel.
All right, I'll recall. We'll see where Mr. Ortega is.
Thank you.
19-2-47, in the interest of AV and ANV, a child. Mr. Pena?
Yes, we're present, Your Honor. I'm not sure if my client's on yet.
I'm here.
Okay.
I'm here too.
Would you please mark as conferring, Your Honor?
Yes, and I'm sorry, Mr. It's Villarreal is all I have. Who had answered on the?
This is Renato Villarreal. I'm here with Alyssa right now doing this via Zoom meeting or court.
Okay, oh, so you're together. All right, let me rename that. Here's Mr. Ortega. All right, let me open up breakout rooms while we're waiting on that. And did you have anything else, Mr. Pena?
No, I do not, Your Honor.
Okay. Okay, I've opened up breakout rooms. Your client and the respondent, I've given them an invitation, and yourself too, Mr. Pena.
Thank
All
you,
right,
Your
calling Martin Saldivar versus R Construction Company.
Plaintiffs are present, Your Honor.
You're muted, Mr. Ortega.
There we go. Good morning, Judge.
Morning.
Excuse
Yes.
my appearance. I landed in Kentucky, but my bag did not follow me, so I'm waiting for luggage.
I once interviewed for a clerkship with a justice of the Texas Supreme Court wearing sweats because Delta couldn't get my bags to Austin. So I've been there. All right. How long to hear this?
For my motion, Judge, I would say it's a motion for summary judgment. This is the second setting, so 20 minutes.
Okay. All right. Would it be helpful to confer or not right now?
No, we've been here 3 times now. This will be the third.
Okay, I'll mark you 20 to 30 minutes. Come back.
Thank you.
Okay. Frio County Civil Docket in the matter of the marriage of James and Keller. Mr. Ramirez, I saw you're there.
Judge, that should be an agreed order that has been submitted for signature.
Okay. All right.
It
Mr.
is,
Ramirez.
Your Honor. I actually filed that order December the 2nd at 1:37 p.m. It's still sitting, according to 5 minutes ago, in the pending column of the e-file system.
Okay, let me go and look. Give me just a moment. Sign back in. I had this zeroed out.
Yeah, I got an email this morning. So I went to check and it's still sitting in there under pending.
Now I've got 3 pages of stuff. I had it zeroed out.
Surprise.
This is Frio County. I have. That case is not in my, there's some stuff here for Frio County now, but that case is not part of it. If you have the order, if you'll just post it to me in chat, I can sign it and give it to the clerk that way.
Let me see if I can do that, Judge, because I don't know that I'm looking at it now under the under review proposed order. I've got an envelope number if that helps, but I don't know that it's still in my computer since it was already showing up in the e-file system.
Okay.
Hang on one
If either of y'all, I'll let you work on that. If either of y'all have a copy of it, if you can just go to chat and post a copy to me in chat, I will sign it and I get it to Frio County. I don't even see them online.
Okay, I'm pulling it, or I'm trying to see if it's on in my computer, but hang on one second, Judge. I will know that in just a second.
I don't see it on the e-file either, Judge, and either one of our queues.
Okay.
That is so strange.
I know there are orders I've signed more than once because I'll sign it and hit forward and it goes into the ether. All right, Wilson County, in the interest of Selena and Jayle Talamantes.
Case that, Judge, that case was dropped. An agreement was reached.
I do have a modified temporary orders and e-file that I will be forwarding over.
All right, thank you. All right, in the matter of the marriage of Wallish, I saw Mr. Wallish online.
Your
Yes, Your
Honor,
Honor,
we're
here.
ready to do the prove up. We'll get you a decree because there's been some changes that were made just as of yesterday. So we'll get you the decree later, but if we can get the divorce rendered today, that would be wonderful.
I'll mark you number 1.
Thank you.
All right. Matter of the marriage of Fernando and Mary Helen Salas.
She's here.
Okay, where's here?
Mary Salas.
Okay, and are you ready to proceed, ma'am?
Yes.
Okay, I take up the uncontested matters where people are self-represented after those with attorneys. So I will mark you A, and you'll be the first self-represented case I take up.
And Judge, just so you know, Mr. Salas is here in the building. He is with the WC District Clerk. I don't think he answered. He's still muted.
All right. And I'm asking you to unmute Mr. Salas.
And Your Honor, while he's doing that, I just chatted you the Keller temporary orders.
Thank you.
I've got a clerk coming to help Mr. Salas.
Okay, I'll recall.
Ahora? You're not on camera. Oh, no?
Okay, in the matter of the marriage of Maria and Ross Miller.
Maria Miller, present.
And are you ready to proceed, ma'am?
Yes, sir.
I'll mark you B. You'll be the second self-represented case. Name
Thank you.
change for an adult. Keely Hope Harris.
Here, sir.
And are you ready to proceed, ma'am?
Yes, sir.
Sure. All right, I'll mark you C. And the add-on name change, Bryce Alexander Contreras, a child.
Don't sit if you cannot sit.
All right, is there anyone here for, I see a Gabby's iPhone. Gabriel Contreras, is that? Right, ma'am, your phone says you've unmuted, but I'm still unable to hear you.
Is it better?
Yes. Okay, are you ready to proceed? All right. Are you ready to go ahead, ma'am?
Yes, sir.
Okay, I'll mark you D.
Thank you.
Anyone else told to be here today, your case was not called? All right, Ms. Bazzioli, did you answer?
No, Your Honor, I apologize. My child is in the background. I'm on the case with Stacy Goodbread, Your Honor, the Wallace.
Okay,
mother.
okay. All right. Okay, so let me look at the Kruger orders. Let me sign those. All right, Mr. Ramirez, Mr. Lopez, I just sent you copies of
Hang
the.
hang on. Hold on. Okay, Your Honor, I'm present.
I signed the Keller temporary orders. I just sent them to you. I will file those in the e-file system myself shortly.
Wonderful. And Your Honor, the court called another case out of Frio, or yeah, I think it's Frio, called Ennis versus Ennis. And I'm sorry, I must have been digging up that Keller order when the court called it.
I don't believe I called that.
Well, I didn't hear it, but opposing counsel just called me on the phone and said that you had called it and I didn't answer.
What, in Frio County?
Well, now you got me wondering. I think so.
Medina County. What's that?
Oh, it's Medina. I'm sorry. No wonder I'm in the wrong place.
Oh, okay. Yes, Mr. Ennis, that's a different judicial district.
Okay, then let me go ahead and get on them, Judge. Are you and I done today? Because this is the only case I had with you.
Absolutely. You and Mr. Lopez, Mr. Ennis, you're all excused. Thank you.
Thank you.
Okay, the matter of the marriage of Wallish.
Yes, Your Honor. Let me unmute so I don't just have to hold this. I'm ready, and I'd like to call my client Priscilla Wallish.
Hello.
Okay, and is Mr. Wallish here? I saw him. Yes, Matt Wallish.
Yes.
Yes, I'm
Would you
present.
raise your right hands? Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, and is Mr. LaHood, you can put your hands down. And your name, sir? Your name, sir?
Matthew Wallish.
Yes. And your name, ma'am?
Priscilla Wallish.
All right. And Mr. Wallish, your attorney is not present.
Your Honor, I'm here on behalf of Mr. of the LaHood firm with Justin
Oh.
and Mark. I did file an appearance of co-counsel, Your Honor, and so I'm.
Okay, that's fine. I just wasn't sure. We don't have to have both attorneys for approve of. Okay, go ahead, Ms. Goodbread. I thought you were co-counsel with her, not for LaHood.
Oh, sorry, Your Honor. Priscilla, are you married to Matthew Cole Wallish?
Yes, ma'am.
And do you have two children of the marriage, Kylie and Kelsey Wallish?
Yes, ma'am.
Are there any other children of the marriage?
No, ma'am.
Are any other children expected?
No, ma'am.
Are you currently pregnant?
No, ma'am.
Have you lived in the state of Texas for the past 6 months prior to the filing of divorce?
Yes, ma'am.
And in Wilson County, the 90 days prior to filing for the divorce?
Yes, ma'am.
Is your marriage irreconcilable due to discord and conflict of personalities that render the furtherance of the relationship insupportable?
Yes, ma'am.
Okay. Did you and your husband go to mediation with Mike Jackson and reach an agreement in July for the division of property and debt, custody, visitation, and child support?
Yes, ma'am.
Do you believe that to be, to the best of your ability, fair and right, just and equitable?
Yes, ma'am.
Okay. And you're asking the court to approve the MSA and render the divorce today. Are you currently in bankruptcy?
No, ma'am.
And you're not asking for a name change?
No, ma'am.
I have nothing further, Your Honor. Pass the witness.
All right. Counsel, Ms. Pezzioli?
The only question I would have is, Mrs. Wallish, do you believe that the agreed parenting plan in the mediated settlement agreement is in the best interest of the children? And are you asking the court to approve that agreement?
At this time, yes.
No other questions, Your Honor.
Okay. All right. Any other witnesses?
No, Your Honor, I'd just like to let you know that she reached the parenting plan in mediation. She no longer feels it's in the best interest of the child. However, she understands that she's bound by the MSA, and therefore we would like to enter the decree based on that MSA, and we will be getting you an agreed decree shortly.
Okay. All right. And Ms. Pezzioli, do you have any witnesses?
No, I mean, well, my client is here, Your Honor, but I believe she covered all the questions. I could ask my client whether or not he wants to put on the record if he thinks the mediated settlement agreement's in the best interest of the children.
All right. Go ahead and ask him.
Okay. Mr. Wallish, do you Do you agree that the mediated settlement agreement with the parenting plan is still in the best interest of the children? Why or why not?
Yes, Your Honor, as long as it's followed. Just making sure that the kids get their therapy and Priscilla maintains her therapy.
All right. Anything else from either side?
I won't go into all the other violations of the MSA because it's not necessary for today. But no, I just need the divorce rendered today so I can fill in the blank on the decree.
All right. And Ms. Bazzioli, anything else from you?
Not at this time, Your Honor.
Okay, I'll find I have jurisdiction to hear this matter. The petitioner had been a resident of Wilson County for 90 days and of Texas for 6 months when the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were 2 children born during the marriage, and no other children were born, adopted, or expected. I'll find that the language in the MSA is in the children's best interest, and I will approve it. And I'll also find that the respondent has appeared in court with an attorney and announced ready to proceed. I'll find the proposed division of the marital property and debts is just, fair, and equitable. I will approve that. Is there a request for a name change?
No, Your Honor.
All right. I'll render the divorce in open court. Any relief that does not appear in the divorce decree is denied, so this is a final appealable order. And how do you want to have a entry date? Just to make sure.
Your Honor, Ms. Brazioli has the decree. We've made some changes. I think she's close to getting that done. They've had the decree since October 1st. She or somebody at their firm, I should say. I don't think Karen has had it the whole time.
Okay. All right, so do we need an entry date or not?
I don't think so. If there becomes an issue, I'll file a motion. We may have to meet with Mike Jackson to arbitrate language, and that may take us into the new year. That's why we wanted to get the decree done as far as the divorce granted today, so it would clean it up for tax purposes.
Okay, that sounds good. I will then put reset on request and that we're awaiting a filing of the agreed final order.
Thank you, Your Honor.
All right, you're excused. Thank you.
Thank you.
Thank you.
Thank you.
All right, give me just a moment. Give me just a moment, folks. All right. I'm going to make, anybody from my office here? All right, I'm going to make Ms. Kruger the
I'm
host.
here, Judge. Lori.
Oh, there we are. Okay, you were on the next page over. Sorry. Okay, I'm going to make Ms. Riley the host. sorry, I have to reboot my computer because it just does this about twice a week. So it usually takes close to 10 minutes. So I would tell everybody, take a break, come back in 10 minutes or so. I will be back hopefully by then, and hopefully the computer will be working.
Oh, okay. I was gonna say, wait a second. All right, I was just checking because I needed to set my iPad. And he hasn't responded and right away.
Miss Lori,
Yes.
will you ask the Saldivar case if they need a record for the MSJ?
If they need a record on the MSJ?
Yes, ma'am.
Okay.
Lori,
So, let's see.
Lori, we do.
Yeah.
We'll take one.
Yes, you will?
Yes, ma'am.
Okay, so go ahead and report it.
Correct.
Great, thanks.
Thank you, Nietzsche.
Uh-huh.
Ken Fletcher, you're cutting out real bad. It's very hard to hear you. You may need to sign out and come back in.
This is happy Thanksgiving.
Can't understand you, please. You might want to sign out and get a different location.
No, I'm glad you. I know I've got one. I've got.
Yes, let me getting my son ready right now. So give me a
Just log in.
Okay.
We cannot understand you, Mr. Fletcher.
Okay, that's how I get into it now.
Yeah.
And then.
Working. Okay, so you understand now.
All right, I'm back. I'm going to go back and ask the attorneys on the Saldivar case to either post to me in chat whatever documents I need to look at, or to send them to me, send me a Dropbox link, something like that. All right, in the matter of the merits of Salas, you grab that file.
I'm here, Mary Salas.
Yes, ma'am. Hold on. Okay. And are you Fernando Salas?
Yes, Your Honor. Good morning. Yes.
Good morning. Right. And Ms. Salas, I'm asking you to start the video on your electronic device.
I'm sorry, Your Honor.
Speaking to Mary Salas, I'm asking her to start the video.
Yes, sir.
Actually, let me just ask each of you, Mr. and Ms. Salas, do each of you swear or affirm the testimony you may give, and the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Salas, do you have your proposed divorce decree?
I have some copies. I have some copies that I had them printed out at the UPS store, Your Honor. I don't know. I think they gave me the link to them when I came second time to check on my status of my divorce process.
All right, well, sir, in order to grant the divorce, I have to have what's called a divorce decree or final decree of divorce, which is the papers that the judge signs that say that you're divorced. So do you have those?
No, Your Honor. I didn't know how to go about it. This is something that I have never experienced before, you know. I went to like I mentioned, I went to the UPS and had the divorce paperwork printed out at the UPS here in Florida.
Be careful.
All right, sir.
And I filed for no contest. In other words, no contest for her. I don't want nothing from her. I just want, I would like to obtain some very sentimental values, my Class A uniform from the military. And that's all I'm asking. And I don't want her to consent to
well, what I need to tell you though is
What does he have here?
I can't fill out the divorce paperwork for you. I can't go and draft a divorce decree for you. I mean, sometimes I may go too far, but I will, help clarify stuff. I'll ask people, you make sure they have everything written in, but the final decree of divorce has to say what happens to all of your property. I need to tell both of you and the other folks who are online who have divorces, actually, which is the Millers. The law in Texas presumes that everything a married person owns is community property. So whether it's community property or not, the divorce decree has to say what happens to it. And if the divorce decree doesn't either say it is community property and here's how it's being split up, or it doesn't say it's not community property because, for instance, it was owned before the marriage, inherited, something like that. If that doesn't happen, then the law presumes that the ex-husband and ex-wife still own the property together, even though they're divorced. You may have to have a lawsuit in the future to clarify what's going on and divide the property. So that's why the divorce decree needs to be complete. The other thing I need to tell you is that your wife, Ms. Mary Salas, has filed an answer. And in that answer, she has asked for part of your VA benefits and also for part of your retirement from the San Antonio water system.
Mm-hmm. Oh, okay.
There are documents that have to be signed separate from the divorce decree to do things like divide a military retirement, if that's what she's speaking with, or divide other sorts of retirement. It's been a while since I did family law myself as an attorney. As my recollection is, San Antonio water system used to have their own order that they wanted people to use. They didn't want, and it would. So what I'm suggesting is this is probably not something that you want to try and do yourself. You probably ought to, one or both of you, speak to an attorney about getting this done. Because you need
Your Honor,
it divides everything up, and you need it's called a quadro. That's an acronym that divides up, if it's required, the retirement.
Okay, Your Honor. I was married. I only have a 10% disability from my VA. It's hearing loss.
And again, sir, that's the sort of thing you need to discuss with your attorney. I can't generate all of these documents for you. I can tell you that generally disability is not divisible, okay? I don't know if you have any military retirement, but disability is generally not divisible, but that all has to be, you have to work with your attorney and then negotiate with your wife. And if you can't come to an agreement, then you'd have to come back to and have a trial.
I was filing it because I was married to her for 28 years. And I built an addition back in 83, 84. And I was paying property taxes I was paying insurance, and the house property deed was never signed under my name. And I'm not fighting.
All of that needs to be discussed with an attorney.
Yes, I just wanted.
The more you speak, the more I'm telling you that this is not the sort of divorce that people need to be doing themselves. The analogy I give folks is, I can change the spark plugs and the oil on my car, but if I was to tear down the transaxle and try and rebuild it, I think I'd do a lot more damage than good. I'd have to go and hire somebody to do it. If you're asking to get credit for any additions you made to your wife's separate property, or asking to have a water system retirement divided and things like that, that's a lot closer to getting the transaxle rebuilt than it is to changing the oil. So you're really going to need to talk to an attorney about that. So I'm going to put reset on request on this, and I will put down that your wife, ma'am, that you have appeared in this case also, so that we understand that you're both here in front of the case, and it's going to have to be a reset at some future date.
Okay, Your Honor.
I wish both of y'all good luck. I hope you get that worked out.
Thank you, Your Honor. So that's it.
Yes, you're excused. Thank you.
Thank you, Your Honor. You have a good day.
The matter of the marriage of Miller. Let me grab that file. Okay. Mrs. Miller, is Mr. Miller present? And you're muted, ma'am.
Now, can you hear me?
Yes.
Okay. No, sir, he's at work.
Okay, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
And you're married to Ross Clinton Miller?
Yes, sir.
All right. And before this lawsuit was filed, had you been a resident of Wilson County for 90 days and Texas for 6 months?
Yeah.
And has the marriage between you and Mr. Miller become undermined due to a discord or conflict of personalities?
Yeah.
Is there any likelihood the two of you are going to reconcile and live together as husband and wife again?
No, sir.
Okay. And since the date of your marriage, have there been any children born to you?
No.
Are you expecting a child?
No, sir.
All right. And I see you've tendered a final decree of divorce.
Yes, sir.
Now, give me a chance to look this over.
Yes, sir.
And on your there's a document you've attached to your divorce decree called separation agreement that's dated December the 1st of this year.
Yes, sir.
Okay, and you're asking to have that incorporated into your divorce?
Yes, sir.
decree? Okay.
Yes, sir. I forgot to mention it in the divorce decree itself.
All right, but it's been signed by both you and your husband.
Yes, sir.
Okay, and did you hear what I spoke to the Solaces about, that the law presumes that everything a married person owns is community property? So anything that's valuable enough, there might ever be a lawsuit over it. Whoever owns it, whatever you're doing with it, that needs to spell out in the divorce decree that it is part of the, it needs to spell out in the divorce decree who's going to get it, to make sure that you wind up with clear title to it.
Okay.
So is there anything that either of you own, which is real estate, automobiles, tractors, that's
Nothing.
valuable enough, there might be a lawsuit over that, just what you've already listed?
Yes, sir.
Okay. And are you asking for a name change?
No, sir.
Give me just a moment.
Yes, sir.
And are either of you in bankruptcy?
No, sir.
All right, and this is your husband's signature on the divorce decree and on the separation agreement?
Yes, sir.
All right, I find I have jurisdiction to hear this matter. It's been on file for more than 60 days. There's a waiver of citation in the proper format that's been on file for more than 10 days, and the respondent has also signed the divorce decree indicating he's in agreement with the contents thereof. The petitioner had been a resident of Wilson County for 90 days, no Texas for 6 months prior to the time this lawsuit was filed.
Yes, sir.
The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born during the marriage, and none were expected. I find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And I'll pronounce the divorce in open court. All right, ma'am, and that should do it. You've already filled out your Bureau Vital Statistics sheet. So I give this to the clerk's office. You ought to be able to pick up a copy of your divorce decree later this week.
Yes, sir. Thank you so much.
Yes, ma'am, you're excused.
Thank you.
All right, Keely Harris.
Yes, sir.
All right. You ready to proceed?
Yes, sir.
All right. Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. All right. And your
Yes,
name
I
is,
do.
and your name is presently Kaylee Hope Harris,
Yes, sir.
and you want it changed to Caden Tyler Harris.
Yes, that is correct.
Okay. All right, I'll take judicial note. And you were a resident of Wilson County at the time you filed this lawsuit?
Yes, sir, I was.
All right, I'll take judicial notice that there is a return on hand in the file from the Department of Public Safety indicating that there is there's no criminal record in this case. Do you have your proposed order?
Yes, sir, I do. The proposed order, like the petition?
No, the petition is the lawsuit you filed asking me to sign an order that changes your name. And I need the order for me to sign that changes your name.
I don't have
Did you
that,
get these?
sir.
Did you get these documents from TexasLawHelp.org?
Yes, sir, I did.
Okay, if you will go to TexasLawHelp.org, you should be able to download go to whatever part of that website you got your petition from. You should be in the instructions, and you should be able to go and download that file and fill it out. I'm trying to look and see. You ought to say something along the lines of final order changing name of child. I rebooted my computer, but if anything, it's working worse than it was. I was trying to search my name change on the documents that I've signed, but now it's locked up. So anyhow, I'll find out I have jurisdiction to hear this matter. Everything has been proven up. If you will just submit that to the clerk's office, whenever that comes in, I will sign off on it. And
Okay.
it'll be done. I'm going to put order to follow. And you are excused. Have a good day.
Thank you.
Can anybody hear me? And if so, can they please let me know that my mic is working? Because for whatever reason, I can hear now, but it's saying that everybody's mic is.
What's your name, sir? What's your name?
Hello, Mr. Wilson. Ken Fletcher. And I was supposed to have been on here earlier, but my phone has been messing up, and it's just been a mess today.
Okay. Why were you supposed to be in court today?
I got a link I guess a couple of days ago, but I just now saw it on my calendar that Mrs. Riley invited me to come to the court date. I'm petition for a divorce, but my 60 days isn't up until February 8th.
All right, sir. I don't know what's going on there. I'm going to ask you to speak with Ms. Riley about that.
I think I sent that to him in error, Judge, and I believe I followed up with an email telling him that.
Okay. All right, because yes, you're not on the docket today.
Okay. Well, thank you very much. Sorry to waste your time and
No
everybody's.
problem. It's not a
You have a
waste.
great day, sir. Y'all be blessed. Bye.
All right, in the matter of the name change for Bryce Alexander Contreras.
Yes, sir.
All right, and you are Gabriela Contreras?
Yes.
Okay, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? I can't hear anything.
Yes.
Okay. All right. And you're the mother of Bryce Alexander Contreras?
Yes, sir.
Okay. And where is Bryce's father?
He is out of the picture.
Okay, that's not a legally valid answer. Where is Bryce's father?
Well, he lives in Jordanton.
Okay, have his parental rights been terminated?
No, sir.
Okay, then he has to be made a party to this lawsuit. You have to have either get him to come in and consent, or you have to have him served by the sheriff's department or someone in Atascosa County and give him an opportunity to come in and contest the case.
Okay, because whenever I put the paperwork in, no one told me that.
Ma'am, they're not allowed to go out and give legal advice. The clerk's office lets you file papers there, but they're not allowed to go through them and say, hey, wait, you need to do something different here.
Okay.
Again, you're going to have to either get his parental rights terminated or get him to sign off on this, or serve him, give him a chance to show up in court. And if he fails to do that, then you can go forward.
Okay.
All right. Okay, wish you good luck, ma'am.
Thank you.
Judge, I believe that was it for Wilson County.
Hey, you are excused then.
All righty, thank you. Have a good one.
All right. Looks like Mr. Pena is still conferring. Oh, he's back. Yes, sir. You're muted.
Yes, sir. So we've reached an agreement, I believe, and we'd like to just put it on the record.
All right, go ahead.
I'd like to put them actually on in terms of testifying, Your Honor.
Okay. And your client's last name is?
Her last name is Acevedo.
All right, Ms. Acevedo, Mr. Villarreal, would you raise your right hands? Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead, Mr. Pena.
All right. Ms. Acevedo, would you please state your full name for the record?
Alyssa Marie Acevedo.
Are you the petitioner in this cause?
Yes, sir.
Is Genaro Vidal Jr. the respondent in this cause?
Yes, I am.
Ms. Acevedo needs to answer Mr. Villarreal.
Yes.
Oh,
Yes.
Have you lived in the county of Karn
Yes.
for at least 6 months, in the state of Texas for at least 6 months, in the county of Karn for at least 90 days?
Yes, sir.
Are there children?
Yes, sir.
over there.
Okay, ma'am, slow down. Let Mr. Pena finish his question.
Are there children of this union between you and Mr. Villarreal?
Yes.
would you please state their names?
Aiden Villarreal and Alize Villarreal.
All right. Are you asking the court to appoint you both joint managing conservators with you having the exclusive right to establish the residence for the children without geographical limitation?
Yes, sir.
With regard to possession and access, are you asking for a specific agreement that you've reached, which would be a stair-step agreement, and it must be consecutive visitations? Is that correct?
Yes, sir, that's correct.
All right. There are to be 6 visitations on the first, third, and fifth weekend, commencing at 4 p.m. and ending at 6 p.m. on Saturday. And then there are to be 6 consecutive visitation periods beginning at 8 a.m. and ending on 6 p.m. that same Saturday. Following that, there are to be 6 consecutive visitations beginning at 8 a.m. and ending at 9 p.m. on that Saturday. And following that, there are to be 6 consecutive visitations beginning on Friday at 6 p.m. and ending on Saturday at 6 p.m. Is that correct?
Yes, sir.
And thereafter, it is to go to the standard possession order from 6 p.m. on Friday to 6 p.m. on Sunday. Is that correct?
Yes, sir.
All right. You're also asking that the pickup and drop off be at your residence. Is that correct?
Yes, sir.
And you're asking the court to order the parties to use app close as a way of communication. Is that correct?
Yes, sir.
With regard to child support, you're asking for $329 a month beginning on the January the 1st, 2021. Is that correct?
Yes, sir.
All right. With regard to medical support, you're asking that essentially that the government assistance program begin to pay for your support of your children's medical. Is that correct?
Yes, sir.
And you're also asking that there be a mutual injunction against both you and Mr. Villarreal. Is that correct?
Yes, sir.
Is there anything else, Ms. Acevedo?
No, sir.
Your Honor, I pass the witness.
All right, Mr. Villarreal, you will have an opportunity to testify in just a moment, but do you have any questions for Ms. Acevedo at this time?
No, I don't. Everything sounds 100% great with me.
Okay, all right. Go ahead, Mr. Pena.
All right, Mr. Villarreal, please state your name, full name for the record.
My name is Genaro Villarreal Jr.
And you are the biological father of these 2 children that Ms. Acevedo testified to?
Yes, sir.
Now, you've heard Ms. Acevedo basically testify to your agreement. Is the agreement correct?
Yes, sir.
And are you asking the court to follow this agreement?
Yes, sir.
I have no further questions, Your Honor.
All right. Okay, Mr. Villarreal, is there anything else you want me to know?
Such as, like,
sometimes people are just waiting to try and get something out. I'm just asking.
No, sir. I'm trying to make this as easy as possible for all of us, and just comply with what's going on.
Right. And Mr. Pena, how long would it take to get this typed up?
I need about 2 weeks, Your Honor.
Okay, so that'll put us into next year. Let me look. All right, the 6th of January.
All right, Your Honor, I think we'll definitely have it, hopefully before then, and we'll submit it to the court. After
All right, Mr. Villarreal, I'm setting this for January the 6th. And what that means is that's for what's called an entry date. You and Ms. Acevedo and Mr. Pena have worked out an agreement here. Mr. Pena is going to reduce that to writing. If you're in agreement that the document he shows you is what you're have agreed to, or if you have some questions, if you can get that worked out, as long as you sign off on it, no one needs to be in court on January the 6th. All right. If, on the other hand, you are unable to come to an agreement with Mr. Pena, you need to be in court on January the 6th, then we'll have a hearing at that time to work out the disagreements you have. So I'll set this for January the 6th, and I'm hoping that y'all get that worked out. And if you do, just sign it, and I will sign it as soon as it's filed with me.
Okay.
All right, and you're excused at this time.
Thank you, Your Honor.
Thank you.
All right, give me a few minutes. I'm going to come back at 20 after. Let me read the motions for continuance and the motion for summary judgment and response, and I'll be back at 20 after.
Thank you, Judge.
Okay, I'm back. All right, I guess the first thing is that the plaintiff has asked for a continuance.
Yes, Your Honor.
Judge, may I, I don't think I ever received a fiat or a notice of hearing for the continuance. I don't see that it's set, but I could be wrong.
Your Honor, it's part of the response to the motion for summary judgment. It's not a continuance of the trial setting. It is a continuance of the motion for summary judgment. So it's a response that must be filed within 7 days, and it was.
Okay.
Judge, that response, unless Mr. Garcia says that he filed a response 7 days ago, the response that he's referring to, that motion for continuance was already heard by Judge Ellison. I believe Mr. Garcia has filed another motion for continuance, and that's the one that I do not see a fiat for. I don't see a fiat for either one, but I don't see a fiat for that one either.
Your Honor, it was filed within 7 days of this hearing. So there is one motion for continuance and a second motion for continuance that Mr. Butler is going to argue. I'm just letting your Honor know that it's been filed, and it was filed in response to a motion for summary judgment. It is not a standalone motion.
Okay, and I've also been given copies of a motion to compel from the plaintiffs.
Yes, Your Honor, that's just an exhibit to the motion for continuance.
That was already heard, Judge, by Judge Ender.
But we've not gotten a ruling on that, and that goes into our motion for continuance, Your Honor.
And there was a motion for continuance with that as well, Judge. But if I can go back and just make sure I understand, is Mr. Garcia representing to this court that he didn't file a standalone motion for continuance?
It is a motion for continue. I'll answer questions by the court, but it is a.
Yeah, okay. Okay, so what do we, I have a second motion for continuance of the summary judgment hearing that was filed on December 1st.
Correct.
Okay.
And that's the one for which I do not see a setting or a hearing, Judge.
And it was, again, Your Honor, filed in response to the motion for summary judgment that Mr. Ortega set for today. And so, you know, I don't know why we would need to set a fiat for a responsive document to a motion that Mr. Ortega set for hearing.
That's because it's a standalone motion, Judge.
But it's
not.
But it's not.
Okay, all right. So go ahead on the motion for continuance, Mr. Butler.
Thank you, Your Honor. As Mr. Ortega alluded to, we had a.
And I'm sorry, give me just a moment. I'm
yeah. Tell me whenever you're ready, Your Honor.
Okay, I'm sorry. Go ahead, sir.
No, absolutely, Your Honor. So this motion was originally set to be heard on October 1st. When we came in front of Judge Ellison on that day, we informed the court that, you know, we needed to get a continuance because we needed to be able to conduct some discovery on Marathon. At the time, Marathon had refused to comply with any of our discovery requests. Judge Ellison granted the motion for continuance and ordered that the parties comply with the discovery, just, you know, simple routine discovery request between parties. Marathon then, in response to that, continued to object to every single RFP that we sent. They refused to supply any documents, including documents that they are using today in their motion for summary judgment. For example, if you go to the motion to compel, number 2 RFD or RFP that we sent to them says, please produce any contract that would govern the relationship between you and another defendant in the case, R Construction. I know this case is new to your honor, so just real briefly, Marathon owned a site that was operated by R Construction. Our client was operating a piece of heavy machinery. An accident occurred on the site. We've sued R Construction. We've sued Marathon as well under some negligent entrustment theories, and just your typical lawsuit against an owner of the property who's also potentially managing and operating the property. And that's the purpose of our discovery, is to try to determine what is the relationship exactly between R Construction and Marathon. And in response to asking for the contract that governs the relationship between those two parties, defendant objected, said it's overly broad, not reasonably limited in time and scope, and not reasonably calculated due to the discovery of relevant or admissible evidence, and then went one step further and said no contract exists. Marathon then, in their motion for summary judgment that's before the court today, relies in part on that very contract they said doesn't exist. So, they refused to comply with written discovery. They've also refused to put up for deposition any corporate representative that could address any of the corporation-wide issues that we've got with Marathon. And they refused to supply the 2 employees who are listed in the accident report for this very accident. Marathon's 2 employees that are listed in the accident report. And basically what Marathon's tried to do is just run out the clock between the October 1st continuance and today's hearing date, and come back again today and say, Your Honor, look, we've already continued this once. Plaintiffs are just trying to, delay this thing. We're not. We want to conduct discovery. We want to get Marathon's liability, if any, established. And then we want to move down the road. We don't want to have to keep coming back to the court for discovery fights. And as Marathon alluded to, there was a hearing on the motion to compel that's before the court here today. It was heard by a visiting judge, and we've not gotten a ruling on that motion to compel. And so what we're asking for today is a continuance, at least until the time when the visiting judge makes a decision on that motion to compel. And if he does grant our motion to compel, which I would expect that he would, then we'd be given a reasonable time thereafter to be able to conduct discovery without the interference, without the obstruction that Marathon's put up, and be able to conduct that discovery. And then after we've had a reasonable chance to conduct a reasonable discovery, then we'll be happy to come back before the court on Mr. Ortega's motion for summary judgment. And after we've had a time for adequate discovery, if Mr. Ortega is able to be successful on his motion for summary judgment, so be it. But Marathon should not be able to obstruct and attempt to refuse us what is just standard discovery of any parties in civil litigation, and then be able to try to get a motion for summary judgment, in part based upon documents that he has refused to supply to us, and that he's said that don't even exist. So, we'd ask that we be given the continuance until at least a decision on the compel order has been made, and then after that compel order is granted, a reasonable time thereafter. Thank you, Your Honor.
Mr. Ortega?
Yes, sir. Thank you, Judge. Mr. Butler wasn't a part of the last 2 hearings, so let me just correct a couple of issues. Judge Ender is a she. Judge Ender heard the last motion for continuance as part of the motion to compel, and there has been no order granting the plaintiff's request for several reasons. We've already argued this issue twice. And let me back up a little bit, Judge, because what you hear is that Marathon, who, by the way, Mr. Butler has worked for in the past, Marathon is obstructing discovery, and that's absolutely incorrect. And the same argument was made to Judge Ellison earlier, but let me back up and just give the court a little more flavor of why I am so adamant about this summary judgment. Marathon is the property owner or lessee for the lease at issue. Marathon hired subcontractors to do the work. And Judge, I've used this example in the past in front of you and in front of other courts, but I'll just say it. It's as though you own a house and you hire a plumber and an electrician to come do work. While the plumber and electrician are finished with their work and they're backing out of your driveway, they have an accident. That accident is not due to any fault of you as the owner, and the accident is between those two parties. Chapter 95 exists for that reason in this case. Marathon hired two different contractors. Our Construction, whose counsel is on right now, and Tyndall. Tyndall is for whom the plaintiff, Mr. Saldivar, was working. Mr. Saldivar was in his truck when he alleges that the road grader backed into him on Marathon's property. That's it. Marathon had MSAs with both Our Construction and Tyndall. And from the beginning of this case, or at least let me back up, from the beginning of my involvement, I've said, we don't have a dog in this hunt. We're just a property owner. Let us have the case. Well, that didn't happen. So may I share my screen with you, Judge?
Yes, and attorneys, you don't have to ask for permission to share if you've got the floor. Just go ahead.
Okay, thank you. I need to now figure out how I do this because my view has been altered on the on Zoom. See if I can do this, Judge. This is what happens when you work out of a motel room. Here we go. Judge, can you see my screen now?
Yes.
This is a case timeline that I've used for now the third hearing. The date of this accident was May 29th of 2018. And this timeline is critical because I've argued lack of diligence by the plaintiff this entire time. May 28th of 2018, 2.5 years ago, this accident happened. Not between Marathon and anyone, between the plaintiff and another company. On October the 24th of that year, the plaintiffs filed their original lawsuit against Our Construction. In May of 19, when Marathon was not a party, Judge, depositions on written questions were issued to Marathon. May 30th of 2019, a year and a half ago, Marathon responded, this is before my involvement, with a one-page incident report, an MSA amendment, insurance certificates, job orders, and the 6 amendments to the job orders. So when I hear that Marathon has obstructed discovery or is refusing to comply, that flies in the face of all truth, because a year and a half ago, all of this information was provided before Marathon was a party. Now, it wasn't until a year later that the plaintiffs added Marathon as a party to this case. A year later, not in the COVID year, this is up to before COVID, that they took a year to add Marathon. Now, I don't have the date here, Judge, but once I got in, I noticed that the allegations against the defendants, Marathon, Our Construction, and one other, were all merged together. So I filed special exceptions, asking Judge Ellison to grant them so that I could know what exactly was being alleged against Marathon. Special exceptions were granted, and the petition was amended on July 21st. Now, as you heard counsel reference a second ago, quote unquote, this is a typical lawsuit against a property owner. I agree. There were 2 parties involved in the accident, none of Marathon's. I agree. And Judge, starting in August, I told the plaintiffs I'm going to file a summary judgment to get Marathon out of the case, and I did that. So our summary judgment was filed August 28th. And you'll see, Judge, that I then emailed the parties about the hearing on the 1st. The plaintiffs then filed a 3rd amended petition, didn't change the scope of anything. The plaintiffs have never disputed the facts of our summary judgment, and then we got to the hearing. And that was when the plaintiffs asked for a continuance. And Judge, I think it's important to look back at a couple of things. By the way, this is the DWQ, the deposition on written questions that was served May of 2019, to which Marathon responded. And it asked for all incident reports, all statements, pictures, conclusions. It asked for everything. There was no objection. Everything was produced that we had. So again, when I hear that there's an obstruction of discovery, that is not what I expect to see. And I'm going to flip through, Judge, and show one more thing here. What was produced, Your Honor, as part of the deposition on written question, you heard Mr. Butler reference the desire now to take 2 depositions. What Marathon produced was called an event report. It's not an accident investigation. And all this is a report signed by Joe Olivas. Again, this was produced in 2019. I've since produced it. Signed by Joe Olivas. And it just says, facts, while hauling location material, a belly dump driver pulled onto location, and he describes the accident. I only see his name. Mr. Butler referenced 2 names. I don't see another name on this report. And so what we did is we moved forward, Judge, to take care of, or at least address, what I believed the issues were in the case. And those issues are very simple. This is a typical suit against a property owner. It's, did Marathon have control over the site? Now, the fact that Mr. Olivas issued a event report tells us nothing about control. So I addressed those issues in the summary judgment. And Judge, I am fine with the court's discretion to rule on the motion by submission. I am very confident that our motion and our reply address every issue raised in Chapter 95. So I don't necessarily want to argue that right now, unless the court wants me to. But let me continue to show the court why the representation that we were obstructing justice and obstructing discovery and refusing to comply is completely false. In August of 2020, I served supplemental discovery. Judge, can you still see my screen okay?
Yes.
Okay. This asked for all incident reports. We produced Marathon 1. That was the one event report. Then I said, defendant did not have an employee working on the site at the time of the incident. Now, this was in August. We showed up for our summary judgment hearing October 1st, and Mr. Garcia complained to the court that I still need discovery, Judge Ellison. The plaintiffs are refusing to answer written discovery. That's all that was at issue, was the written discovery. And so Judge Ellison said, okay, I'm going to give you time to wrap up your written discovery. But if you come back in 2 months and you don't have more evidence, it's on you. So I set this motion 2+ months down the road. And in the meantime, I thought, I'm going to take the remaining discovery issues. Let me come here. Out of issue. So back in August, I looked for Mr. Garcia's letter where he said there was other discovery he wanted me to answer. So I'm just going to flip through quickly. There was interrogatory number 2, interrogatory 13, 15, request for production 15 and 16. So I went and grabbed our discovery after the October 1st hearing, and I decided on my own to supplement because I didn't want the issue of, we need another continuance, or Mr. Ortega is thwarting or obstructing discovery. So in my second supplemental discovery, served October 19, to Mr. Butler included, So when he says, I'm not removing my objections and I'm not answering discovery, Judge, I supplemented with interrogatory number 2, identify any person associated with the safety or work at the site. I removed the objections and said there is no Marathon employee responsible for the safety of the 2 subcontractors. Then I went to number 13. You remember the ones that I just read. At issue from Mr. Garcia says, please describe any investigation. Remove my objections. Marathon did not conduct an investigation. The MSA requires the subcontractors to report certain incidents to Marathon. Marathon completed a form based on information relayed by the subcontractors, which is that Marathon 1. This data entry was completed by Joe Olivas, the person in charge. That's how he's listed on the event report of entering information. But he was not on site, did not witness the incident, and did not investigate the incident. The only folks responsible for that per MSA are the folks that were there. And Judge, remember, the plaintiff still has the 2 defendants in this case, and they're represented by counsel. And I continued to the request for production. 16, any documents relating to any meetings concerning the incident. There's no objection, Judge. I said there's none. We didn't have a dog in this hunt. So we didn't go out and investigate. We didn't do anything. I supplemented all the discovery that was referenced in Mr. Garcia's letter from August and that he then complained about on October 1st. And then finally, Judge, we have our summary judgment. And the summary judgment includes, Your Honor, the declaration of Shane Rice. Shane Rice is the drilling superintendent for Marathon. And again, Your Honor, this was produced back in August. The plaintiff has had our outline for why we don't belong in this case since August. And Mr. Rice describes the fact that Marathon would send bid notices to these contractors, our construction in Tyndall. And their conduct on site was their conduct. But if they had an accident or an incident, they had to give us basic information. But we were not involved in the process undertaken by the contractors to build a pad, deliver material. Marathon did not control or dictate the method or manner in which RCI or Tyndall performed the work. And Marathon did not have an employee or equipment on site. We didn't learn about the incident until it was called as required. And the person in charge of the report, Mr. Olivas, was not present on site at the time of the incident. So, Judge, not only are there MSAs that were produced a year before being added to the case, but then we have provided an affidavit from Shane Rice. We have served interrogatory answers verified, confirming that we have no control, that there was no involvement by Marathon in this incident. And Judge, just to be clear, I am making no representation about fault on any other party to this case, namely the defendants. Whoever's in the case for the defendants, they can argue their own case. I'm just here to say, I just hired a plumber and an electrician. They had an accident pulling out of my driveway, it's up to them. So instead of, there's enough pockets in the case. I'm not sure why the plaintiff wants to keep us in, especially after they have conducted reasonable discovery. There's deposition or questions, interrogatories, request for production. Mr. Butler said we need to conduct reasonable discovery. Judge, with what they've asked us to do and what we've produced, that is more than reasonable. To continue fishing and now to say we want to go take depositions of a corporate representative, of Mr. Olivas, and one other person is completely unreasonable because there is no basis to suggest that Marathon had any involvement in this incident other than as a landowner. So as I bring this back home, Your Honor, Chapter 95 is very specific. Mr. Plaintiff, you have to show that we had control of the site, number one, before you add us to the suit. And that's a Rule 13 issue, and I've pled Rule 13. because a plaintiff cannot sign a petition or a party for the sake of experiment by the court. That is sanctionable conduct, or at least conduct for which a court can dismiss a case. I've also included Chapter 95 to say we aren't anything other than a property owner. And so with respect to the continuance, of course, I do object to the fact that the plaintiffs are raising that issue that I don't believe has been properly set. But to the extent that the court is going to consider argument, Judge, I think I have shown that counsel's contention that we have obstructed discovery and refused to comply is completely inaccurate. We have not only replied, but we've continued to confirm and straighten out every issue that could be involved in our motion or the discovery. And I agree with counsel that this is just a typical case against a property owner. Marathon should be out of the case. And I have made this argument in the 2 previous hearings with co-defense counsel involved. If I have misrepresented Marathon's involvement with respect to the other defendants, they can argue that. They can bring it up and they can say, no, Ortega, you're wrong. But they haven't, because their cases are completely separate and distinct from a property owner. I believe that the motion for summary judgment should be heard. And Judge, again, I would agree to that by submission by the court, but I certainly do not believe a continuance is warranted in light of all the discovery that I have shown. And there are other documents that I could show the court, but of course, it becomes slightly redundant. So I would ask that the plaintiff's now 3rd request for a continuance be denied, that the court consider the motion and the response and the reply as submitted, and that Marathon be dismissed from this case as it should have been on October 1st of 2020.
Okay.
Your Honor, just a couple of things to hit at here. There was a lot of representations made by opposing counsel, and we have a habit of doing this when we have these hearings, that things that aren't exactly correct get brought up. I've never worked for Marathon. I think this court's seen me in front of him enough times to know that I'm on the other side of Marathon. So whatever assertion Mr. Ortega is making about me being a client from Marathon, I just checked with my accounting office to make sure about that. Something hadn't slipped through, but that's not the case. Also, I was present for the October 1st hearing that Mr. Ortega said I wasn't there at. I'm sorry my presence wasn't more meaningful to him, but I was there. I know exactly what was argued. And going to the plumber and electrician issue that he keeps bringing up, there would be liability for the landowner if there was a measure of control that the landowner was putting on the plumber or on the electrician, or if there was a property defect that caused that accident. And those are items that would be permitted to be explored during discovery. A landowner, a property owner who is running this site like Marathon is presumed to have control over the issues that are being conducted on their property for their benefit. And so we should be permitted to conduct reasonable discovery through depositions to be able to determine the level of control that Marathon has on these workers. And Your Honor, I'll split screen with you real quick, because an issue was made that there's not a second person, it's just one guy. Well, that's not the case. Let's see if I can learn how to split screen. You see, this is the R Construction incident report, and it lists Russell Wrights as the Marathon rep. And so that's where we get the second Marathon employee that we need to discuss. So, Your Honor, it's just a very simple request here that we be permitted to conduct the same type of discovery that any other plaintiff would be able to conduct in a personal injury case, which is to be able to conduct the reasonable deposition testimony of fact witnesses and the corporate representative for Marathon Oil. Thank you.
Let me ask 2 questions. One to both the attorneys. because I've never had this come up. What is the relationship between documents produced before you're a party to litigation under a deposition on written questions, and then once you become a actual litigant, a defendant? Are they just automatically adopted? Do you have to do something affirmative? Is it as if it never happened and you still have a duty to reproduce, kill more trees and reproduce everything again as a party and not as someone who's got a DWQ?
I can answer that, Your Honor. If you produce as a non-party witness documents in response to a DWQ, those records are a part of the case, and they are admitted for all evidentiary purposes, especially when you supply them or support them by affidavit, as you would with a subpoena response, which Marathon did in this case. I'm put in this position a little more now every day. The only time that that rule doesn't apply is if the court doesn't have jurisdiction or venue, jurisdiction over the deponent. So for example, a Houston court wants to ask or require a Midland company to produce documents. We can object and say it's beyond the subpoena range of the court. Therefore, anything we produce is going to be informal and without affidavit. In that case, then it couldn't be used. In this case, that wasn't what happened. Marathon voluntarily produced the documents in response to subpoena with proven up form. So those are part of the case.
And what exactly did the judge take under advisement as far as to compel?
Sure, and that's the one, Judge, I didn't want there to be confusion that Mr. Butler wasn't present for. It was a motion to compel us to now produce deponents. So the first continuance in front of Ellison, as the court will read, was regarding written discovery, which we supplemented. Then the plaintiff came back and said, okay, no, but now we need depositions. And Judge Ender heard that motion for continuance or motion to compel along with Mr. Garcia's request for continuance. And the same arguments were made. And Judge, I do disagree with one point made by a couple of points made by Mr. Butler. And just for the record, Mr. Butler will need to remember that he was local counsel picking a jury for Marathon, and I'll provide that case name later. But that's a conflict issue I don't want to put on the record. The issue that I have with his argument is that for some reason, he or the plaintiff has a right to depositions in cases. And that is not the law. If you don't have a reasonable basis to demand a deposition, so in this case, where we have provided a verified answer to interrogatory that Mr. Olivas has no dog in the hunt other than filling out the form, and that Marathon didn't control the property, then there is no reasonable basis for depositions. We've already produced the evidence that we need to produce, verified by interrogatories and verified by affidavit.
And the plaintiff?
I was not hired by Marathon on that case. They use my office, and so this is such a stupid argument. So, Your Honor, we believe that we absolutely have a right. I mean, the Texas Rules of Civil Procedure allow for the conducting of oral depositions of parties to the case. We've made a good faith prima facie showing on our pleadings that we had the right to continue in this case and be able to conduct reasonable discovery. I don't know what more to add than the fact that a party has the chance to be able to conduct discovery on a defendant when they've brought suit.
Okay, and does the plaintiff have an objection to submitting the motion for summary judgment by submission and not by oral arguments?
I don't think we have an issue. I mean, I'll let Jesus take that one. He's in charge of arguing our response, so I'd prefer him to answer that question.
No, Your Honor. I mean, we can have it heard orally or by submission, but when it's ripe, the problem is We haven't been allowed to conduct discovery. We've been thwarted every way. By the way, the DWQs, the only page that Marathon produced was the event report. It never produced the contracts. It never produced them in response to a request for production. It did it as a sword when they filed their motion for summary judgment. That is the first time we're seeing those contracts, even though they said none existed. And Judge Ellison, he did not say limit your discovery to written discovery. He said, go conduct discovery, and I don't want any excuse that you haven't conducted it. Well, you know, we haven't been able to do it. I even have to file a motion to compel. It wasn't a motion to continue the summary judgment. And I'm only saying this because Mr. Butler wasn't present in front of Judge Ender. It was plaintiff's motion to compel the same depositions that we need. And so if it's ripe, I don't have an objection for submission, but it's not ripe.
Okay. And let me ask one more time. So was the MSA provided under the deposition for written question or not? Because Mr. Ortega read a list of documents. It was the MSA, the bunch of amendments to it, or an amendment and a bunch of change orders?
It was not, Your Honor.
Judge, to clear this one up, I will add to your chat room or send you how you want the response to the DWQs.
And I will send the ones that we got from the company, and I'm letting you know that we got the event report. That's what we got. And so if Mr. Ortega produced it, I didn't get it from the discovery company.
Judge, I just to make sure, I wasn't involved in May of 19 because we weren't sued until a year later. I have produced all the information in this case, but that was from Marathon. So it'll come from the DWQ responses that were provided to the court reporting service, if you want them, just to clarify whose story is accurate here.
I'll ask both of you to just go ahead and post that in chat. And you may have heard the Frio County case where Tommy Ramirez came in and said that he filed his temporary orders on December 2nd and nobody can find them. All the clerks and the coordinator and everybody says, we don't have them, they're not there. I go into the e-file system and pull up that case, and it says the last document that was filed was the proposed temporary orders on December 2nd. So it shows when I pull it up, it won't let me look at them, but so I don't know. I know it may well be that Marathon packaged a bunch of stuff up and it didn't all make it through to the plaintiff. I don't know. So I will leave this running for a few minutes to allow you to post that. And what I propose to do is I'm going to take this under advisement until Judge Ender makes a ruling. I will not consider it until depositions have an opportunity to take place, if that's what Judge Ender rules. If Judge Ender does not grant new discovery or does not grant the motion to compel, then I will consider it based on the submissions that I have right now.
Judge, is there
it turns out that we find out that actually whatever was produced to the court reporting service, unless we finds out that Mr. Garcia did not receive that.
Well, and I'm going to go through it. It's been a long time, and honestly, I don't want to misrepresent. I'm going to produce what I got. Maybe I got it and my memory fails me. I don't want to make a misrepresentation to the court. I will just produce, and maybe it is that I got it. The point is that Marathon just appeared in May, and we started conducting May of this year, and I haven't had an opportunity to take depots. But I don't want to make a misrepresentation to the court. Maybe I did get it, Your Honor. I'm not looking at it.
Okay.
To be fair.
Judge, is there a way that I can send that separately? Because I'm in a motel room. I have to go to my office and have them connect it. Can I send that to you separately? Or it may be that Mr. Garcia finds what I was just talking about and I don't have to.
That's fine. What I would suggest, if you would set up a Dropbox or Dropbox type link and just copy all of the attorneys.
We'll do that. That way I can get it correctly. And Judge, that issue, just to wrap this with a bow, is a little bit of a red herring. Because yes, the MSAs were produced in 2019. I think the court's going to see. But even if they weren't produced until I filed my summary judgment in August, there's been zero evidence to suggest that control issue. And so I just don't want to go off too far into stuff that creates a side issue. But again, we'll produce it to the extent that Mr. Garcia doesn't find what I've referenced.
Anything else right now?
No, sir. Thank you for your time.
Okay, and actually, hold on just a moment. Let me just a moment to look for something. Okay, we're gonna have to put this on my list of things to go back and look at when we hear from Judge Ender, and someone's gonna need to let me know what the result is of that. I've just posted a tickler entry request form. I think Mr. Butler's seen those before. If the attorneys would download those and just fill them out and submit to the coordinator's office. So if they have that, and we won't have a date on there other than after Judge Ender issues a ruling for me to go back and look at it, but whatever you're asking for me to do. And I guess I'll ask you to wait until you either come to a resolution or you figure out you can't come to a resolution on the question of whether the MSA was produced in 2019. And it's a pretty self-explanatory form once you look at it.
Very good.
Who would be excused, Your Honor?
Yes, once you've downloaded that, you're free to go.
Thank you.
Oh, let me
Yes.
jump over. Is that in the chat room, Judge? I'm sorry.
Yes, I just posted that in chat.
Tickler entry request form?
Yes.
Okay. Thank you, Judge.
Thank you.
All right. Have a good day. All right, Lachey, I will see you in the morning.